Hey everyone, today we're going to talk about Chapter 20, Agency. Agency. Let's get started. So when we're talking about agency, we're really talking about three different entities, if you will. We're talking about the principal, we're talking about the agent, and we're talking about third parties. And agency really deals with the interaction between these three entities. The principal has the power. They initiate the agency. They empower the agent. The agent, they have the authority to act on behalf of the principal. They are given that authority by the principal. They are limited in that authority by the principal. Okay? And then third parties. Third parties are those that are affected by this relationship between the principal and the agent. Let's talk about how agency is created. So, as I've indicated, the principal initiates the agency relationship. And one big fundamental thing that we don't really spend any time on is the fact that you, much like contract law, you can't contract with somebody to perform an illegal act. You can't have an agent perform an illegal act for you. You can't hire an agent to harm someone. That would be illegal, and that would not be a viable agency relationship. Now, we're going to talk about, throughout this course, something that's called restatements of the law. So let's sort of take a time out and talk about that, because this chapter references and footnotes the restatement third for agency. So restatements of the law are simply volumes, and it doesn't have to be a physical volume. You can go out to the BGSU electronic library and pull up the restatement third of agency. And when I say restatement third, really it's called the restatement of the law third agency. And that just means that there was a second and then there was a first. So this is the third. And so you're going to see your book reference the second, but actually there is a third now. So restatements are volumes, getting back to what we started talking about, they're volumes or they're electronic documents that really pull together the law in an area and put it into one place. Now, we're not necessarily talking about enacted law, because with enacted law, statutes, you can look at your, for example, in Ohio, the Ohio Revised Code, and see exactly what the statute said. Restatements deal more with common law, pulling together all those. So these are experts who pull together all these different principles of the law and put them together in one place. Now, it's not the law, okay? It's not mandatory authority that a judge must follow, but it's persuasive authority. So you'll see in an opinion, and we may see this throughout the course, you may see in an opinion that a judge says something, and then he's going to back up what he says by a reference to the restatement of the law. So the judge, he or she, is saying, this is what the law is, and I'm going to back up what I'm saying by citing the restatement of the law. Okay? So again, not mandatory authority, but certainly persuasive authority. Not controlling authority, does not have to be obeyed, but it is persuasive. So the different kinds of agency. You have an express agency, which is agency by agreement. You have agency by implied authority, apparent agency or agency by estoppel, and then agency by ratification. And your book references these different types of agency. So express agency or agency by agreement. This is where you principal agrees with the agent that the agent will be an agent for the principal. So it's expressly stated. It's very intentional, and it can be done orally or it can be done in writing. Now, let me say here, and my bias is probably going to become apparent throughout this course, is that written documents, maybe it's because I went to law school, but written documents are just always better than a handshake. I know there's something very noble about saying let's shake on it, and that's all well and good. But when there becomes a problem, when there becomes a disagreement, you really want to be able to look at a document which lays out the terms of what you agreed to, so that there's not a question, there's not a fading of the memory as to what you agreed to. So again, we'll go back to talking about agency now. You have an express agency, and that can be orally or in writing. Now, powers of attorney. You can have a general power of attorney where you give somebody wide range of authority. You can have a specific power of attorney where you empower somebody to do something specifically for you. And then you have a durable power of attorney. It's much like that term is used with regard to durable goods. They're long-lasting goods. If you have a purse or a handbag or a satchel that's durable, well, that's an item that's going to hold up over time. And the same thing with the durable power of attorney. You can see this section I've cited here from the Ohio Revised Code. The Ohio Revised Code is enacted law, and so they define durable. It says durable with respect to a power of attorney means not terminated by the principal's incapacity. So if the principal who granted the authority by an express agency, by an agency by agreement, becomes incapacitated and it's a durable power of attorney, then that power of attorney is not extinguished because the principal became incapacitated. So that is a durable power of attorney. It survives the incapacity of the principal. A little bit more on power of attorneys here. Again, this is a section of the Ohio Revised Code. You'll recall that I said we're going to reference quite a bit the Ohio Revised Code because you're maybe sitting in Ohio, maybe a lot of you are from Bowling Green. So here, section 1337.25, execution of a power of attorney. And so here in Ohio, a power of attorney must be signed by the principal. Okay, so power of attorney. Let's talk about agency by implied authority. Agency by applied authority. Now here's an example. I'm just going to read this for you. We can read it together. This is from that citation I've listed at the bottom. When a principal grants an agent express authority to complete a task, they also grant that agent authority to take any steps reasonably necessary for the completion of that task. For example, if a principal asks an agent to take his car to the mechanic, the agent has the implied authority to drive that car. Now, what if I'm the agent? You've given me the authority to take the car to a mechanic, but I go ahead and take that car and drive down to Orlando, Florida and go to Disney World. Well, there I have exceeded the bounds of that agency relationship. Even though there's no written agreement there that says that I couldn't do that, I certainly did not have the authority to do that. It was not implied that I should do that by the agency relationship. So I do not have the implied authority to drive to Orlando. So in that situation, I was given express authority to take the car to the mechanic, and I had implied authority to drive the car to the mechanic, but I certainly did not have the implied authority to drive to Disney World. Let's talk about agency by estoppel. Agency by estoppel. Now, this word estoppel is a funny word. It's a word pretty much limited, I think, to the law. And so you're going to hear this in, I think, another part of the course where we talk about this word estoppel. And so I've just included a definition here from dictionary.com. It means a bar or impediment preventing a party from asserting a fact or a claim inconsistent with a position that party previously took, either by conduct or words, especially where a representation has been relied or acted upon by others. So here, third parties, we introduce the actors of the third party. So here, third parties are relying on something. Third parties have justifiably relied in their belief that an agency existed. Okay? The agency did something, represented to the third party something, and the third party justifiably relied on that. So, probably be very helpful to talk about an example of agency by estoppel. So, let's say you own a car dealership and you are the principal. You have a brand new salesman, and that salesman is in training. So that salesman is your agent, not because they're in training, but you hired the salesman to sell cars on your behalf. He is your agent. So you, as the owner of the car dealership, you are the principal, as we've said. Now, let's assume that your salesman uses your dealership's email address and business card, and the business card has your dealership logo and his name printed on it, to sell a car for less than what you would have wanted him to sell the car for. Remember, he's in training. So he presents his business card to somebody who comes in, the buyer, who wants to buy a car, and he ends up selling the car for less than what you wanted him to sell the car for. And you, as the principal, were unaware of this sale. Well, the buyer, the third party, doesn't have any reason to not believe that the agent is representing the dealership or the principal. There's nothing about the situation that makes the buyer not think that the agent is legitimately acting on behalf of the principal. Now, you as the principal want to deny this sale. You're going to lose money on this sale. In this instance, the third party must prove that their belief that the salesman was a legitimate agent was reasonable. And here, I think they'd be able to do that. So here, this is agency by estoppel. The principal is estopped from saying that the sale was not a good sale. Even though he's unhappy about it, he's estopped from doing that. Let's say the agent sold the car in the parking lot of Walmart, and the agent still presented a business card. And it's a little harder case because there, perhaps it's a little more clear that the agent is not acting on behalf of the principal. Maybe there's not justifiable reliance by the buyer. But I think you get the idea here, at least I hope you do, that we're talking about apparent agency here, or agency by estoppel. The agent has represented himself to be an agent. There's nothing about the representation that makes you think that he is not the agent, and the agent then the principal is estopped or prevented from saying that the agent was not representing you in the sale of the car, or that the sale of the car was not a good sale. Let's talk about agency by ratification. And so here's a reference to the book. I've included the citation there. So all of these requirements must be met for there to be an agency by ratification. First, an individual must misrepresent themselves as an agent for another party. Second, the principal accepts or ratifies the unauthorized act. Next, the principal must have complete knowledge of all material facts regarding the contract. And finally, the principal must ratify the entirety of the agent's act. So let's apply that to the hypothetical we just talked about. So that previous example, the buyer is complaining to the agent about how you, as the principal, have tried to negate the deal. You've tried to get out of the deal. And finally, you come to your senses and you say, all right, I will agree to the sale. The principal doing that is ratifying the agency, okay? That is agency by ratification, okay? It's coming out and they're ratifying the entirety of the agent's act. Let's talk about different kinds of agency relationships. There's the principal and agent. We've talked about that. Then there's employer and employee. So employees are agents of their employers. What I really want to focus on is this idea of the employer and an independent contractor. So one of the ways this really becomes important is in the context of tort liability. And torts are instances where someone has breached a duty that they owed to someone else, and that breach of duty has resulted in harm. Okay? So that's a tort. So that's like, so a slip and fall incident would be an example of a tort. So let's say you're a store owner and you hire someone to fix your overhead lights. And in fixing the overhead lights, they drop a light on a customer's head. Now, you don't want to be responsible for that as the store owner. So you want to be able to say, well, that's the fault of the person who was installing the lights. That's not my fault, even though it occurred on my property. I am not responsible for that as the store owner. I hired them for their expertise. So one of the most important questions, if not the most important question, is how much control do you exert over this person who you've hired to fix the lights? If they're an independent contractor, then you have a shield against liability to the person who was injured by the independent contractor, okay? You probably have a contract with the independent contractor. In that contract with the independent contractor, they've probably agreed to indemnify you because of their actions. You've hired them because of their expertise. You've hired them because you want that protection. You've hired them because you wanted to create a barrier between them and you. Okay, so the important question here is, well, how much control did you exert over them? So in other words, were they really an independent contractor? Let's go back to the light example. So if you supplied them with the ladder, the tools, and told them how to do it, then chances are they're no longer an independent contractor, and you're not going to be shielded from liability. They're going to be more like an employee. We're going to talk about this a little bit. As long as that employee was working within the course and scope of their employment, as long as that employee was doing things normally an employee in this situation does, okay, you're going to be liable for what that employee did. Now, so hopefully what you're trying to do with an independent contractor is you're trying to turn the work over to them so that you are not responsible for their negligence. Another example, let's say someone comes to my house to clean my house, okay? I want to make sure I don't tell them exactly how to do it and supply them all the tools. At that point, there's a real danger of them becoming my household employee. So for tax purposes, I don't want them to be my employee. So I need to make sure that I maintain an arm's length relationship with them. So let's talk about duties of the principal and the agent. Let's talk about the duties of the principal. So the principal has the duty to pay the agent, to compensate them, unless you've agreed they're going to do or act as an agent for free. A duty of a principal is to reimburse them for expenses they incur in the course of their agency. It's also a duty to indemnify them in case they get sued by a third party for something the agent has done while fulfilling the goals and wishes of the principal. Now again, talked about this though, it's a little complicated. If the agent is an independent contractor, then you don't want to indemnify them. You want them to indemnify you, and you're probably going to put that in your contract. Cooperation. You can't stand in the way. And it doesn't make sense to do so, but you can't stand in the way of the agent fulfilling his duties for you. And then finally, provide working conditions that are safe. And again, the law and facts get kind of complicated. Yes, it's important that you provide a safe working environment, but let's say you've hired an independent contractor to clean out the insides of hazardous storage tanks. Well, you cannot make that safe. You might make the surrounding areas safe, but you can't do that. So again, getting back to where that's why it's so important to have an independent contractor who has the expertise to do those types of things. Let's talk about the duties of the agent. Well, they have a duty of loyalty. They've been hired to represent the principal. They've been hired as an agent of the principal. So it goes without saying they have a duty to be loyal. Let's see how that manifests itself in real life. Now, this is a section of Marathon's Code of Business Conduct. And if you look at the section at the top, it says that a business, this is also directed to employees. So employees are going to read this, and the employee is going to look at this as this is their responsibility. So a business opportunity that you learn about because of your job belongs to the company. Never take for yourself or direct to any immediate family member or friend opportunities that are discovered on the job. For example, you should not attempt to acquire an interest in property or other assets in which our company might reasonably be expected to have an interest without first offering the opportunity to the company. So here what the Code of Business Conduct is trying to do is to lay out the loyalty of the employee to the company. And what they're saying is that the employee has a responsibility to not take for themselves an opportunity that they find on behalf of the company while working for the company. They need to present that back to the principal or their employer. Okay? I think that's a good example of the duty of loyalty. Some additional duties that the book talks about with regard to the agent back to the principal. They have the duty of notification. So an agent must keep the principal advised of critical information. So let's say the principal has hired an agent to conduct settlement negotiations on their behalf. Well, that agent then has the responsibility to keep the principal informed as to what's going on with the settlement negotiations. Okay? So there's a duty of notification to keep the principal advised. There's a duty of performance. They must do the job, and as the book states, quote, with reasonable skill and care, end quote. obedience. They must act in accordance with the principal's wishes, but they don't have to obey bad wishes. They don't have to do things that the principal wants them to do that are unethical or illegal. And finally, there needs to be an accounting back to the principal. They need to provide proper accounting. So when I think of a classic principal-agent relationship, I think about a client-attorney-client relationship where the client is the principal and the agent is the attorney, and the agent-attorney has the responsibility to not commingle the funds of the client with other clients that he has. So there needs to be a proper accounting. So with regard to agent authority, you have express authority. That's authority that's expressly given to the agent. You have implied authority. So that is authority to do things that, while not expressly delineated, and we think we've already hit on this, while not expressly delineated, are necessary to perform the express authority. Let's give you another example. Let's say that I have express authority to settle a case on behalf of my client. My client wants me to settle the case for up to $100,000. I have the implied authority to do what is legal and ethical to settle the case for up to $100,000. It probably means entering into settlement negotiations and offering something less than $100,000. Now, let's say I settle the case for more than $100,000. Well, I might have had apparent authority to do that when you think about that from the perspective of the third party, but I didn't have implied or express authority to do that, really, from the principal. Okay, so there we touched on, I know it can get confusing. There we talked about apparent authority and authority by estoppel. And we talked about that earlier in this presentation. So let's talk about another strange word or phrase, and that's respondeat superior. Respondeat superior. That means in Latin, let the superior speak. So this talks about the responsibility of the principal for the actions of the agent. And really, we use this phrase when we're talking about the employer or employee and employee relationship. So generally, the employer is liable for the acts of their employees as long as those acts are committed within the scope of the employee's employment, even if those acts are negligent acts. Okay? So let's say that you're the owner of a retail establishment and you ask your employee to stock shelves with tomato sauce that had just come in on a recent shipment. In doing so, your employee drops a jar which breaks and spills on the floor, and while the employee is getting a mop and a wet floor sign, a third party, a customer, slips and falls and breaks their arm. Under this doctrine of a respondeat superior, you as the owner are responsible for employees' actions, even if those actions are negligent, because they were committed in the course of the employee's employment. Okay, let's change that up a little bit. Let's say that the employee's sworn enemy comes into the store and that the employee intentionally spilled tomato sauce on the floor, hoping that his enemy would slip and fall. Within the scope of the employee's employment? Probably not. Okay? Why? Well, you as the principal did not authorize that act, and your interests were not being advanced by that act. Now, in the real world, you as the store owner are probably going to get sued, and maybe your employee as well, but they probably don't have the wherewithal to pay any judgment. And in the real world, you're going to get sued because you probably have the deeper pocket. But in any event, we're talking about a question of fact here. Was the employee's act within the scope of their employment? And if it was within the scope of their employment, then respondeat superior says that the employer is responsible for the acts of the employee. And finally, let's talk about how this agency relationship is terminated or ended. And your book talks about termination by acts of the parties and termination by operation of law. So we're just going to briefly hit on these. You can read about these. So termination by acts of the parties. So one of the examples is given is, or the principles that's given is time lapse. So the time for the agency expires, the set time, the time that was set by the express agreement, that expires. Perhaps the purpose of the agency was achieved. So the book used example of you hired an agent to sell your house and the house sold. So that's now the agency relationship is terminated. The agency couldn't keep doing things for you. The agency is terminated. A mutual agreement, you both decide that it's over. Perhaps the principal revokes the agency. They have the power. Remember, they have the power to do that. Or the agency can renounce the relationship. And finally, termination by operation of the law. So death of either party will extinguish the agency relationship. Insanity, bankruptcy, circumstances change. So the book gives an example of a painting that becomes a lot more valuable than the agency anticipated. There's a change in the law which makes perhaps the subject of the agency illegal. Maybe the agency is no longer possible. And again, the book, I think, talks about this now. The painting that the agent was selling on behalf of the principal is destroyed. So now the purpose of the agency is impossible. And so the agency no longer exists. And the book gives also the example of war. Well, that was a longer video than normal, but I appreciate your attention and I will see you next time.